Please sit down. Who is Uncle? Oh. Barka kwana ku lafiya lo ya gida.
Thank you very much. It is my pleasure to invite the Solicitor General of the Federation and the Permanent Secretary, Mr. Dayo Abata-San, to
give the opportunity to the Honorable Attorney General to set the record straight. As you are aware that the press and journalists always believe that the other side must be heard in every situation we find ourselves. There has been some reports which the Honorable Attorney General intends to bring to the public through the journalists and to set the record straight. The Honorable Attorney General, sir.
Thank you. This press release, or indeed the press conference, is intended to set the record straight with particular reference to issues relating to judgment dates. The attention of the Honorable Attorney General of the Federation has been drawn to deliberate and malicious smear campaigns being driven by some unscrupulous media outfits against the person and office of the Chief of Staff to the President, the Honorable Minister of Finance, Budget and National Planning, and Attorney General of the Federation as it relates to settlement of certain judgment debts arising from the deductions and refunds due to the state and local governments from the Referees Club loan refund. I am more particular about the Premium Times publication titled Malami, Gambari, Silence Governors Forum and Force CVN to pay 133 billion judgment debt, and indeed the Sahara Reporters report titled Malami Ignored Fraud Warning while pushing payment of suspicious 159 billion debt. The Federal Ministry of Justice wishes to set records straight in order to correct willful falsehood and obliterate the nuisance value of the reports. The Chief of Staff to the President and the Attorney General of the Federation did not at any time force the Central Bank of Nigeria to pay 350 million US dollars to any person or entity, neither are they mounting pressure to effect hasty disbursement of the sum of 480 million US dollars. In fact, as a matter of fact, under the current policy of the federal government to settle certain outstanding judgments, there will be no cash payment. And that is by deliberate design to sustain the policy of accountability and transparency. We wish to state that the judgment dates in question are linked to third-party claims arising from the disbursement of the Paris Club refunds to the states and local government. It will be recalled the Federal High Court in suit number FHC ABJ CS/130 of 2013, and more particular about the year, considering that the suit was commenced in 2013, long before the coming in place of this government under the leadership of President Muhammadu Buhari. The parties involved are Linus International Limited and 235 others versus the federal government of Nigeria and 3 others. In a judgment delivered on 3rd December 2013, the court directed federal government to pay the sum of 3,188,079,505.96 to the local governments, being their share of the sums utilized by federal government for settlement of various club debts. Part of the sum of 3,188,079,505 naira 96 kobo were also to be paid to the consultants engaged in the recovery exercise or for contracts awarded by ALGO. Those were the spirit of the judgment delivered by the Federal High Court in 2013 before the coming in place of the government of President Muhammadu Buhari. The consultant contractors have subsequently obtained judgment to enforce their entitlement based on which garnishee order absolutes were made against CBN. Based on request for compliance with the above judgments, the Office of the Attorney General on 3rd May 2016 requested the EFCC to investigate the genesis of the judgment and garnishee proceedings in suit number FHC/ABJ/CS/130/2013 involving Linus International Limited and 238 others versus the federal government of Nigeria and 3 others. This is in tune and in line with the policy of the Office of the Attorney General to support and assist the federal government in avoidance of liabilities that are found or perhaps that have some undertones of fraud and associated things, in line with the established tradition by which the Office of the Attorney General coordinated the undertone investigation associated with P&ID out of sheer desire to support the federal government in avoidance of liabilities. So notwithstanding the fact that there existed a judgment of the Court of Law, the Office of the Attorney General tried as much as possible to look into the probable fraudulent undertones with a view to support the federal government in avoidance of frivolous liabilities. So arising from that referral to the EFCC for undertone investigation relating to the judgment, EFCC confirmed the validity and performance of the contracts awarded to Rio Nigeria Limited by Algon. EFCC also confirmed part performance of the contract. EFCC also confirmed the validity of the judgment obtained by Rio. It is also to be noted that EFCC confirmed validity of Ted Edwards' engagement by Algon to recover funds for the local government council, and also confirmed the validity of the judgment obtained by Ted Edwards. This is about due diligence and indeed intended to be sure and certain that the government is indeed not subjected and open to the payment of unjustified judgment debts. In order to substantiate the foregoing, the Office of the Attorney General, again, even after the receipt of the report of the EFCC, requested the Department of State Services to investigate the third-party claims. The DSS also confirmed the engagement of both Rio Nigeria Limited and Ted Edwards by Algon and the validity of the respective judgment dates. These are the extra due diligence efforts made by the Office of the Attorney General out of desire to ensure that no frivolous judgments as some is eventually paid. The DSS also established that RIOC executed about 50% of its claims. That is, the contract has so far reached 50% completion as at the time of the report. It is to be noted that both Algon and AGF, Governors Forum, by various letters, consented to the payment of the third-party claims, and neither of them has challenged the judgments in question. So the judgment in questions were at no point challenged by the Governors Forum. The judgments in question were at no point challenged by Algon, and they have indeed written to the Office of the Attorney General on the request of the Attorney General for such confirmation, confirming the authenticity and validity of these claims. Some of the judgments are based on mutual terms of settlement entered into between the judgment creditor and Nigerian Governors Forum. The initial payment of 350 million in 2018 to settle part of the third-party claim was duly approved by Mr. President, and indeed was a product, the payments effected was a product of settlement by which the Office of the Attorney General forced the parties to consider settlement, and a settlement was eventually also reached that gave the federal government certain proportionate concession, notwithstanding the judgment. So at this time, Professor Ibrahim Gambari, the Chief of Staff, was not in office as Chief of Staff. This belies and indeed establishes the mischievous undertones associated with the report, among others. We wish to state categorically that neither the Chief of Staff nor the Attorney General are making any pressure or move to hurriedly disburse the stated sum of 418 million. The Office of the Attorney General did not only express any hastiness, but indeed took time to ensure at the end of the day that necessary state instruments are brought to bear in terms of understanding, verifying, and ensuring that the federal government is as much as possible protected against frivolous claims. So the involvement of the Office of the Attorney General in the settlement of the judgment debt is based on the fact that Garnishi Order Absolute has been made against the Central Bank of Nigeria to attach federal government funds, since the federal government is a trustee over the federal account, and the funds were made to the states and local governments from the federation account. We wish to put it on record that the said publication are false and fabricated to achieve the desired objectives of the sponsors. The processing and payment of any judgment debt is subjected to due process, and all requisite approvals must naturally be obtained. The Chief of Staff and the Honorable Attorney General have not violated any presidential directive in this regard, while the concerns raised by NGF are being addressed through the right channels at the appropriate quarters, while reiterating again that both Algon and Governors Forum gave their consent to the payment, and indeed, I am happy to state that both the Premium Times and indeed Sahara reporters were apparently complicit on account of their failure to expose the 2013 judgment that had been in place, which was not interrogated, which was never ever brought to the attention of the general public over time. On this note, distinguished ladies and gentlemen, it is the position of the Office of the Attorney General and Minister of Justice that the publications were indeed frivolous, mischievous, and designed to smear the person and the Office of the Attorney General without due justification, without due investigative journalism, compliance with necessary rules and procedures associated with investigative journalism. I rest my case. Thank you, distinguished ladies and gentlemen.
Thank you very much. Right to give opportunity for one or two questions. Okay, thank you very much.
the 2025 budget, it passed through the Secretariat to prepare the budget estimate for the judiciary and take it straight to the National Assembly for appropriation as advocated by
my question is in respect of your comment about cash forwarded to the Office of the Attorney General, which was delegated by the PAMSEC to the FOI department, seeking the federal ministries and departments are responsible for catering for their own judgment debts.
From previous premium times, which indeed constitute one of the papers on the basis of which we are here this morning or this afternoon to respond, I would like to accord premium times an opportunity of distracting this gathering. I would rather give them a further opportunity, if they intend to ask one, to restrict themselves to the subject matter of the press conference, while giving my commitment to engage him outside in terms of responding to these questions that are not in any way directly linked to the subject matter of discussions. So I still agree that you are entitled to be briefed as far as your question is concerned, but not at this forum, because it has the capacity to distract the attention of the audience, considering that Premium Times is indeed alleged to be party to mischievous dissemination of the information in contention. I wouldn't like to answer it. I'm very sorry about that. On the second question asked by Mr. John on Daily Trust, I will urge the Permanent Secretary to please respond to it.
Thank you very much, Honorable Secretary. Is that the government is considering the possibility of not paying direct cash. So that's looking at the possibility of some other legal tenders which are not cash. That is the clearance which I need to make. And on the issue of you said you requested under FOI, and the information given was were not. I think you used the word not sufficient. I expected that you have always been coming to the office, and you could have written to us and request for further and better information. If the information that we have supplied is not sufficient, and I can still say that the doors are still open. If what we have written, what you have written has not answered your query, please come back. We will give you enough information. And on the issue of the judgment profile of the government, you have to understand that the federal government has so many departments, that's MDS, ministries, departments, and agencies. Now, initially, before now, all the judgments were housed in the Ministry of Justice. But later, it was found out that if there's no budget for it, becomes an issue, and you have to look at the possibility of the pressures of garnishing proceedings. That is why there's another circular which states that each MDA should fund any judgment arising from their respective ministry, departments, and agencies. And you will agree that makes sense, because that will be able to caution every MDA if you know that you give contract or you incur any judgment debt, and you think that another agency is going to pay it, it becomes a bit reckless. But in a situation in which you might be forced to pay from your own overhead or recurring, then that has already put some little sanity. So it is a bit difficult now, since those judgments they are no more warehoused in the Ministry of Justice. It is very difficult in specific terms to determine the government profile, the judgment profile as it as at today. Thank you very much.
Thank you very much for the